What's up, everyone? It's the Law School Lumberjack. I hope you're having a great day. Today, we're going to be starting a new series, Corporations Law 101, also known as Business Organizations 101. So what this series will focus on is the basic law surrounding corporate law that you will likely see in your law school courses. So in our first video, we're going to go through two basic topics that will be taught in your corporations law or business organizations course. Firstly, we will go through the law surrounding sole proprietorships and just give a brief primer around that, and also give a brief primer and explanation surrounding general partnerships. In subsequent videos, we will focus on limited partnerships and limited liability partnerships, as well as a deep dive into corporations and the law surrounding corporations, directors, and officers. So without further ado, let's start with sole proprietorships. So what a sole proprietorship essentially is, it's a business that an individual is running either in their own name or with a trade name, but it has not been registered as a corporation. So the sole proprietorship is generally the most basic business relationship one can have. It's what you see even young children doing when they put their name out in a lemonade stand. That is arguably a sole proprietorship. Now, sole proprietorships can be registered or unregistered, depending on what jurisdiction you're in or what statute you're looking at. Certain industries and the use of certain names require registration, but generally a sole proprietorship is not necessarily required to be registered. Now, some of the benefits of a sole proprietorship are that it's cheap to start up and dissolve, especially if it's unregistered. You can imagine with the lemonade stand example, all you have to do is get the materials, put a sign up, and you're ready to go. Now, the main negative you will see, which is actually the main negative you'll see with a general partnership as well, is that the sole proprietor in question, or the person who's running the business, faces what we call unlimited liability. And what unlimited liability essentially means is that the sole proprietor is liable for any of the debts and liabilities of the sole proprietorship. So using the lemonade stand, for example, let's say the individual in question uses water that has bacteria in it by accident. Everyone who has that lemonade gets sick, and then the party who's running the lemonade stand gets sued. Well, that person who's running the lemonade stand, if it's a sole proprietorship, would be responsible for all of that liability. All the court cases, all the damages, that would fall on the sole proprietor. So that's basically just a brief primer on what a sole proprietorship is and some of the advantages and disadvantages of that business arrangement. So let's move on to a general partnership. Now, when it comes to a general partnership, the partnership itself is not a separate legal entity. The partnership is essentially a business relationship. So unlike with a corporation or an individual, who are legal entities, a partnership essentially creates a business relationship that comes with it certain rights, benefits, and liabilities. Now, general partnerships can either be created by agreement, which is through a partnership agreement, or under the common law and under most statutes, they can be created by conduct. So you don't actually have to take formal steps to create a partnership. By definition, a partnership is a group of two or more people carrying on business in common with a view to profit. Let's break that down because there's kind of three elements to that. Firstly, they have to carry on business. Secondly, in common. And thirdly, with a view to profit. So case law has interpreted that to suggest that carrying on business generally requires some ongoing activity between the parties. So simply co-owning an asset that makes money is usually not enough, or a one-off transaction is usually not enough. The parties have to continually transact or work together with a view to profit for the partnership to be considered a partnership. Now, with the in common with a view to profit, it's important to note that if parties are sharing profits, court cases have suggested that if two or more individuals are sharing profits and it's not through a corporation, that there's this rebuttable presumption that the parties are in a partnership, and it's up to the parties in question to prove that the partnership does not exist even though they are sharing profits. Working with a view to profit doesn't require that you actually do profit, it just means that you're endeavoring to make money together. I'm sure you're wondering, why does this matter? Why is it such a big deal if statute or common law deems me to be a partnership? Well, one of the big downfalls of being in a general partnership compared to a limited partnership or corporations is that all partners in a general partnership face what's called unlimited liability, which means that all partners are jointly and severally liable for any of the liabilities and debts faced by the partnership, even if those are the fault of their other partner. So for example, in the lemonade stand example, let's say instead of one person, you have Adam and Bob working together in this lemonade stand and creating a partnership. Well, if Adam's away one day and Bob uses the bacteria-infused water and gets everyone sick, even though the mistake was no fault of Adam's, Adam is jointly and severally liable for all the liability that Bob caused. At law, there is something called contribution and indemnity, where Adam can go after Bob for whatever he has to pay out of pocket for Bob's negligence, but the fact still remains that Adam, to the rest of the world or all third parties who use their product, is still liable, and people can still claim damages against Adam. So this is one example where general partnerships, if people go in knowing that they're in a partnership and have the requisite protections either through insurance or agreements in place, the downfalls may be mitigated. This just shows a situation where it can have grave impacts on a party if they're deemed to be partners. Now, a lot of benefits between the parties are assumed to be 50-50 unless the partnership agreement states otherwise. So if parties are leaving it up to the statute, common law, or they have no partnership agreement, then it's assumed that with a general partnership, all parties are going to be treated equally. So all parties will have an equal right to the partnership property. If there's two parties, it'll be 50-50. All parties will have an equal right to the profits made by the company. Again, two people, it's assumed 50-50. And all parties will have, presumably, the responsibility to pay the same amount of capital required to create the partnership. Now, these benefits can be altered, as I said before, by a partnership agreement. However, what a partnership agreement cannot do is it cannot prevent the partners from being liable to the outside world. So again, this video was just meant to be a brief primer on what a sole proprietorship and what a general partnership are. It's certainly not meant to be a comprehensive study. If this video was helpful, I would really appreciate if you would like and subscribe. Thank you very much. Take care.